the new regulations that you mentioned as were passed on the 29th of December 2020. So long and short of it, in terms of the new regulations that were passed, and I'll actually read this verbatim from the regulations that were passed, a person may not be evicted from his or her land or home or have his or her place of residence demolished for the duration of the national state of disaster. And you see, the issue is that most people stop reading at that point in the legislation, and they've kind of understood, and this is from my experience down at the court, listening in at the magistrates, listening at the judges, as well as the people leading their arguments, as well as presenting some of our own matters at court, is that a number of tenants will come to court and having read half of the section say that, look, there's a blanket ban on evictions at this stage in Cape Town. And unfortunately, tenants they are putting themselves at risk by not canvassing the entire legislation as it stands at this time. But we'll go into a little bit further into that a little bit later. But at this stage, let me read into the rest of it. It mentions that, look, you may not be evicted from your place of residence during the national state of lockdown unless a competent court has granted an order authorizing the eviction or demolition. So many people have taken this to be a step away from the ordinary, but in actual fact, this is almost exactly the same position that is in ordinary courses of evictions in the PI Act, that nobody may be evicted from their place of residence or their land or their home in any event without a court order of court. That would be met with a very quick spoliation order, a restitution, something like that, and get you back into the house in no time. So in terms of where we stood with that, we are at the same point that we were at under normal circumstances. Where it gets even further into the specific circumstances as when a person may or may not be evicted is more so when it comes to clause 2 of the regulations, in that a court has a power to suspend that order of termination of the lease agreement, alternatively of ejectment by the sheriff. And the court may do this when it is not just or equitable to evict someone on that date or at this time during the national lockdown. Where we sat previously with the regulations as they stood through the preceding parts of the disaster regulation, national disaster, up until the 29th of December, was that the courts kind of stopped at that. They didn't give any flesh as to what consideration was to be taken into account when attorneys, when tenants, when landlords were approaching the court and when they were needing these eviction orders. So what they've actually done this time is they've actually fleshed it out quite a bit more. And I think at this stage, because there are a number of points, I think it's about 6 different points that need to be considered when a court can view the staying of eviction as just and equitable. And I think it's vitally important at this stage that landlords as well as tenants familiarize themselves with this as a major repercussion, not only on the current rental contract that you have at the moment, but the future rental contracts you could possibly into, as well as just your future financial well-being, because it all ties in with that. And I think maybe just as a point of departure, it's necessary for me to deviate at this stage and say that, like all other contracts, a lease agreement is based on an agreement between the parties there too. So the best way to change the terms thereof is again by agreement. And I think I will get back to that point a bit later, but that is also something that the regulations as of the 29th of December have tried to push forward as well. So at this stage, as I'll lead back into your main question was, are evictions allowed at this stage? They are. And the court has fleshed out when and why they would be allowed at this stage. And that's via some court judgments that have been passed in the time that has passed since then, but more so by the regulations that sit in front of us. And if I may, before I get into the instances that I actually want to that the legislation has put forth, let me just ask: do you have any questions at this stage as to what I've mentioned thus far?
No, if I'm listening to you, the current situation is you're right, no different than the previous situation. And even if you look at those sub-regulations dealing with under what circumstances the court can now basically enforce a court order. I mean, during normal circumstances, a court can also suspend an eviction order. So the court, for example, say,
Yeah.
let's say they said to be like in 2020, like before the lockdown, before the coronavirus, the court most probably could have said, I'm evicting you, but I'm suspending the eviction order,
Mm,
pending you moving out in 2 months' time, or pending this or pending that. So if the only difference now is we have the PI Act,
exactly.
and we have this additional regulation that puts certain type of additional things which the court can consider and look at. But at the end of the day is, if you're an unlawful occupier, you're an unlawful occupier, and you should be
Exactly.
evicted. You should leave at some point. Yeah.
100%. And that's kind of what the courts have also put forth in the new regulations as of the 29th of December, is that they noticed that the previous regulations were far too onerous on the landlords and the owners of the property, in that it made a, you'd say, a blanket ban on evictions at that stage, though that is arguable. However, at this stage, they've kind of put in direct clauses in the current regulations that actually take into consideration the prejudice that's caused to the landlord and any obstruction of justice that would take place. And obviously, one would say that, look, the enforcement of a contract where two parties are in agreement is a signed document, and where one party is providing, by way of a lease contract, the accommodation, and the other party is defaulting by not the non-payment. It is a, in the eyes of the court, it's generally a clear-cut case because it's a contract, and it would be then very difficult for them to, say, continuously delay this matter without them stepping on the toes of someone who is entitled to justice in their own event. And I know that it is a balanced approach that needs to be taken in evictions, and especially with the historical aspects that go with South Africa, and more so now during the period of national lockdown. So what the court here has done is they've gone even further, and with that um, clause that allows the considerations of the landlord to be taken into effect, the legislature has even gone a step further and ensured that, by way of regulation, I believe it is H, the sub-regulation H, that the court must now also consider whether the landlord has actually made a good faith effort to enter into renegotiations with the tenant at the end of the day. And that brings me all the way back to what I was saying at the beginning, that, look, at the end of the day, a lease agreement is a contract, a contract from beginning to end. And the courts have considered that, look, the everyone is at a difficult and impasse at the moment. It is onerous on both landlords, on tenants. There are multiple rights that need to be weighed up and balanced, and that is essentially the only way that landlords, tenants, and South Africa as a whole are going to benefit, if we are all willing to see the human element to the law as well, and possibly move forward from there. So the courts now have actually gone that step further, as I mentioned, and necessitated that negotiations have to take place, or a good faith negotiations have to be attempted before an eviction can take place, which is a step further than has ever happened in our PI legislation. It is a almost a step into the realm of the legislature looking into a contract, which hasn't occurred before, in my opinion. But it is an interesting step, especially in light of what the situation that we find ourselves in now. So it brings me back to the point that, look, evictions to us are a last resort at the end of the day. Even as an attorney, we'd much rather prefer to negotiate with both sides, get everyone to a round table, and hopefully we can reach an agreement that would be beneficial to all parties at the end of the day. Because one cannot take the closed eye approach and say that, look, it's always beneficial for a landlord to evict a non-paying tenant. That can be far from the truth in some cases. It's it's a known fact that it's not a renter's market in South Africa at the moment. Tenants generally have the negotiating power. There's a surplus of rental property. And so at this stage, landlords find themselves in a difficult position substituting tenants that don't pay. So it is often beneficial for a landlord to come to the party, perhaps look at maybe reducing the rental temporarily, maybe a brief write-off of interest, or maybe even just stay in some payments for a later period of time. And in that way, the landlord has the benefit of not having to screen tenants in future, not having to go through all the vetting processes and those kinds of things. As I say, the devil is, you'd rather deal with that at the end of the day. And then also for tenants, it goes two ways in that, look, you are protected in staying in the property, but we tenants need to also understand that, look, you still have the rental contract that exists in the background, and what you want to do is you want to firstly secure your primary needs, being obviously your accommodation, your ability to care and nurture yourself and your family, but also you need to consider the financial implications in future that will be had. And that's why I say that, look, for tenants, it's trying to rely on merely delaying the eviction is not often, or is almost never a beneficial situation. The reason there being is that all the rental that you accrues during that time will still fall due to your account. The landlord will almost certainly not write off those amounts if you're unwilling to negotiate. Those amounts will accrue interest over time as well. And furthermore, you'll be unfortunately left with, in the instance of a signed lease agreement, most likely you'll be left with the attorney's fees on the other side as well, which are, it's another heap of fees that you don't necessarily want to be paying at a stage where money is short in South Africa. Let's be honest, that people, we need to find ways to that everyone can reach a resolute and sound outcome beneficial to all. So that's why I always drive forth the point that, look, evictions at court are the last port of call, and wherever possible, a roundtable should be hosted, and negotiations that can ultimately, hopefully, suit both parties would be the first prize. But at the end of the day, should negotiations fall through, the situation that stands is the one that lays in the contract, and tenants need to be aware, and many of them do find themselves in a tricky situation that, look, the legislation may allow you to delay, but always bear in mind that you still have your interests of your financial well-being and your family to protect in future. So that is the major concern that I have with the appearances that I see in court and the delay in eviction matters that go forward. Whereas I think that a number of them should, or almost certainly with a good attorney or someone that's not acrimonious in their nature, but more so looking to a resolutive outcome, would be able to reach a plan suitable to all parties. And yeah, so that's why I say that, look, negotiations always first port of call when it comes to evictions. And ultimately, the contract does stand at the end of the day. And whether you're willing to honor it now or in X amount of days, it will still fall due. I'm not sure if that answers the question that you do have. If you have any questions, do let me know, and I can go into it a bit further in detail. I know I've given quite a lot of information in one go there. So yeah, do let me know if you have any questions as well.
No, no, that's fine. Thank you for that. What I'm picking up is that if there is no lease agreement, if the landlord really doesn't want you to live on his premises, I mean that is a right he has, and he doesn't want to to renegotiate with you. He wants you to leave because maybe he has good reasons for that. Maybe he has a child that's getting married.
Hmm.
He wants to move into the premises. He wants to sell the premises, renovate it, make his place maybe a bit bigger now because it's a an ensuite as the case may be. It seems to me that at the end of the days, if you are illegal on the premises, there is no lease agreement, you will have to leave. No court will say, I don't care, whatever the case may be, you can stay here indefinitely or you can stay here till whenever you decide to. So that will happen.
No.
So well, I'm reading into the lines and I'm seeing that if you are at default as a tenant, try to come to an agreement with the landlord, either to delay the process of eviction. So say, tell the landlord, I will leave here, give me 3 months and I will leave in 3 months' time. And if I do not leave in 3 months' time, then you can approach the court and we can put it into writing, as opposed to the tenant playing the landlord all the time and saying, okay,
Exactly.
take me to court and what, as the case may be. So tell me quickly, if I am a landlord or a tenant, but let's say with a landlord first, and I have a tenant that's problematic, etc., and I knock on your office, what will you generally do at the first point of call?
My first port of call would generally be to pick up the phone and try and speak to the tenant. Um, 99% of the time, there's often a communication breakdown. Obviously, when financial strains hit, I know people can take it personally as well, and they tend to close up in that. So there often tends to be a miscommunication between the landlord and the tenant. And I find that 90% of the time, a friendly phone call at the onset of a matter from a independent party, such as an attorney or perhaps a mediator or something like that, goes a very long way in trying to reach a resolute middle ground. And I think, yeah,
Sorry, I muted myself there.
if you're
And
the tenant,
what would happen if I'm the
yeah, if
tenant?
you're the tenant, I would go pretty much the same way because you'd obviously have to just put forth to the landlord that there's benefit in keeping you. Look, you're willing if you are a genuine bona fide tenant, willing to honor the rental contract in future, or you've just found yourself short because of COVID-19 and those kinds of things. Again, the best thing is to enter into genuine negotiations and not try and play, as you said earlier, play the game or play the eviction process. Unfortunately, there are no winners at that stage when people try and just curtail and delay and, yeah, just rather curtail the process.
So, Jody, while I have you here, and also some lot of relevant questions
Mm.
which people might want to know. What does it generally cost to evict someone from the home? Let's say you're a landlord, and I'll deal later on
Mhm.
with the cost of defending it. But I'm a landlord, and
Yeah,
this person doesn't want to leave. He doesn't pay rental. He doesn't want to leave. What would it cost me generally to employ an attorney
yeah,
to get to have him evicted?
yeah. Look, it's a difficult question to say at the onset because evictions can range from a 2-day process if we can reach a settlement or an agreement and the person then decides, look, I will actually vacate. We've had a good discussion, I'll vacate at the end of the month. And then you'll be charged a minimal fee. An attorney will charge you just the bare basics for doing a couple phone calls and that kind of thing. Alternatively, you can be slapped with an eviction that gets opposed at court with the acrimonious parties who just can't see eye to eye and who can't reach a date for agreement, with extenuating issues such as possibly minor children, elderly persons, or estate evictions, which are another ball game we won't even touch on today, which are in terms of the Extension of Security of Tenure Act, which are out in rural lands, unproclaimed lands. Um, but yeah, so evictions are difficult because those evictions can go on for anything for a period of a year, sometimes even longer. And then, as we mentioned, that look, if the parties can't see eye to eye and the court has to stay the process, there's even a further delay, which could see a court possibly going into eviction going into a year and a half period. Those are extremely unlikely. As I say, almost all of the time evictions will settle. But as I say, an unopposed eviction generally looking at anywhere from about 2,000 Rand to 9,000, 10,000 Rand. It all depends on the circumstances, what occurs, and yeah, how long the matter goes on. But obviously, we do prefer to look at a matter and provide uh, any person with a personalized quotation based on the matter, just so that they have a actual understanding of the actual cost and the time that one would estimate the matter to occur over.
So I agree with you. It's a difficult question to answer. I mean, if someone asks you, how much will
Mm,
I charge to do a case? It's almost like asking somebody how long is the string, or asking
mm,
somebody on the phone how much will it charge? How much will it charge me to build me a house? There's so many variables applicable, so it's really hard to do that. So, but I think the take home is that it will cost a few thousand rand at the bare minimum, and it could
yeah,
possibly be very expensive if this specific tenant does not want to leave, and if you have to employ the office of the sheriff to remove the specific tenant from the home. So
exactly.
the sheriff will have to get some manpower involved. He'll charge you a few thousand bucks
Mm,
for that as well. Jody, this is moving on. What? Let's say I intend leasing my premises, or I'm a tenant and
mm.
I intend leasing premises as well. So I come to your office. What would be your first step of call? Will you assist me in drafting the agreement? What will you do?
Well, we run a full service from beginning to end here at our office. So we would attend to the drafting of the lease agreements. We are able to vet and assess your potential incoming tenants as well as do credit history checks and those kinds of things. But yeah, first port of call is always a solid lease agreement. That is the number one protection for both the tenant and the landlord. You'd want everything recorded in writing and a complete agreement that deals with default, with occupation, with all the aspects beginning to end. Too often do I find defective lease agreements that unfortunately delay matters at court at a later stage, um, where there are unnecessary points that need to be argued about. It wastes time, it wastes cost at the end of the day. So the best point to start off is with a solid lease agreement, and also a recommendation that many landlords don't do is a proper authoritative incoming and outgoing inspection.
What does that entail? The incoming and outgoing inspection. What
Yeah.
do I look at?
Yeah. So we've now jumped to the point where you've actually now sourced your tenant, you've chosen the person that you do want in your property, and you've got to the point of, okay, now you're happy, they've signed the agreement, they're moving in on Monday. Generally, many landlords are like, hand over the keys, they, in the excitement, they hand over the property and they wait until the lease ends, and then they start dealing with the tenants in that again. And many of them find themselves in a property that's been damaged. There's maybe general damages that need to be attended to at the cause of the tenant, of course, and only to be met at the court stage with the court returning that, look, you've done an outgoing inspection, you've noted that there's X amount of damage, but you failed to record what the state of the property was at the date of occupation. And this incoming inspection cannot merely be a couple of pictures of the flat. And that's what a number of landlords have done in the past and under the previous dispensation, and they've just kind of relied on those. However, one now needs a signed incoming and outgoing inspection. Alternatively, an agreed to via email, something like that, with a yes response would still suffice if we were to argue it. But you would need a proper signed document, or a document listing all the defects, and then pictures would be in addition to that, and just prove by way of that. So I think it's very important that landlords take the initial steps, and also possibly just look to consulting with an attorney just to make sure that all the basic steps at the beginning are consulted with, as well as tenants, just so that they can ensure that they are protected when the lease agreement does eventually terminate.
Now that's very interesting, what you mentioned now, because
Mm.
things are very happy at the start. Someone wants
Mm.
accommodation, they're excited. It's a new home, a new place, bigger premises, and so on. Now they move in. There's a bit of damage, but that was probably ignored for now. Once there's problems
Yeah,
later on in the line, we can't afford the rental or things start breaking, then I start complaining, and then I say, but you didn't.
exactly.
So that's very very good advice for you. Jody, one last question before we can go on again. Is difference between commercial property and residential property,
Mm.
a home and an office. Is there a big
Yeah.
difference in the eviction proceedings applicable, or is it more or less the same?
There is quite a big difference. The courts have always distinguished between the need to protect a person's primary residence first and foremost, and secondly, um, the commercial properties unfortunately don't get the same protection under the disaster regulations, nor under the PI Act. Technically, you can still evict someone under the common law from a commercial property, whereas you can't do that in terms of a residential property. So the it's chalk and cheese between the two at the moment, to be honest, and that's the line to draw between that.
So the bottom line is, when it comes to commercial property, even never paid your rent,
Hmm.
there's no lease agreement, you'll have to go. They'll give you 1 month notice or a few
The,
days notice.
the long and short of it is pretty much yes, that is the situation. But again, I hop on the point that please do into negotiations with your landlord once again, because that is often the best port of call. And maybe if you are having a difficult time, to get an independent attorney or an independent mediator to try and step in on those commercial property mediations.
Yeah, I would imagine that the main problem comes about whereby you're not paying your rental. I mean, with commercial property, if you pay the rental to the end of the lease agreement, they won't bother you. But
Mm,
if you
exactly.
do, so if you're seeing a problem arising, if you're seeing next month, I have a bit of a financial problem, contact your landlord, discuss it with him or her, and come to an understanding.
Mm,
And I'm saying that's especially in
exactly.
lockdown.
Yeah. And then obviously, if persons do want to cancel a commercial rentals and they do fall within being a sole proprietor, they should obviously look to the protection afforded to them in terms of the Consumer Protection Act, which would go a long way in terms of that. But that we could also look to have another discussion on that, because that's a whole nother kettle of fish altogether. Mm.
Jody, thank you very much for that. So I think we can end it off now. We passed the half an hour mark. So this was a very interesting discussion we had over here. At least I'm more informed about evictions during the national lockdown, adjusted level 3. What I'm picking up, and you can just tell me if I summarize it correctly. You can still evict somebody, and if the person never paid the rental, the person is in an unlawful occupier. It might take a bit more longer because the court might have to be a bit more considerate. Maybe in the past, the court will grant you maybe 2 months to leave your premises. Now they must probably grant you 3 months, a bit more time. But hiding
Mm.
behind the term, it's lockdown, it's COVID-19, does not necessarily assist you or stops the court from actually
Exactly.
enforcing the powers to evict someone.
Exactly. And I think if you have other options, you would rather not delay it, and you would rather protect your financial well-being in future and try and look to exercise in one of those other options if they are available to you. But we know, unfortunately, circumstances do prevail, and they are not available to everybody at the end of the day.
Okay. No, wonderful. Thank you very much for that,
Sure.
Jody. So, everybody, we have Jody Blount from attorney partner from Schneider, Galloon, Reef and Co. A big law firm in the same building like me, but they like 11 floors higher. So, as we mentioned earlier on, they pay more rent than me, I would presume. So, thank you very much for that. He's an eviction law expert, commercial expert, lease agreements and matters regarding banks, etc. Jody, thank you very much for your time. We are having another webinar next week. We'll try to have it every week. I do have my family law webinars, which I deal with family law aspects, but I think it's very important that we deal with relevant matters in society as well. Like evictions,
Mm.
because people are being evicted or people are not paying rent and the COVID-19, etc. And having sound legal advice to those specific people will be very useful. If you are watching this video,
Yeah.
thank you very much. Please share it if you can. At the end of this video, there will be all the details of Jody. You're welcome to contact his law firm, and they'll be more than happy to assist you. As I mentioned early on, Jody is one of those, forward-thinking, forward-going lawyers. They're very digitalized. They're very, on par with things. They make use of the normal stuff, WhatsApp, Facebook, and those type of things, which you don't much find in the older generation of lawyers, but you require that. Jody, any last words on your side before we wrap up?
No, I would just like to say thank you so much for allowing Schneider Galloon to come onto your platform. It's always a pleasure to work with you. And yeah, thanks to all the viewers for listening as well. If they have any questions, feel free to contact me at any stage. We are very happy to assist.
Wonderful. Thank you very much for that. Okay, and if you are watching this video, as I mentioned earlier, share it, and here's our details. Have a wonderful day, everybody. Take care, Jody. I'll chat to you soon.
All the best. Thank you.